So thank you for the introduction and the ringing endorsement of the firm. We do like to think that we're there to help, and we do a good job of that, I think. So a little bit more about Mintz Levin. We are a full-service law firm, meaning sort of all the commercial things. We don't generally do injury law or kind of things that, if you get in a car accident, we're probably not the guys to call. But we have an immigration practice, corporate practice, employment, IP, both prosecution and litigation, which means sort of getting your own IP rights and then enforcing them or defending them against others. Real estate, pretty much everything that a small to gigantic company might need or want. Our main office is in Boston. I'm in our San Diego office, which is our fourth biggest office, but certainly our best office. And as Gwendolyn said, I am a Berkeley alum. I'm actually a 3-time Berkeley alum. I did my undergrad in chemistry and then wandered across the quad and did a PhD and master's degree in civil and environmental engineering. And then decided that I didn't want to be an academic and puttered around a little bit trying to figure out what to do with my life and stumbled across being a patent attorney. So I'm sure my thesis advisor probably didn't envision that as extending his family tree, but anyway, it still seems to like it. That's about it. So I do patents in a large range of things. I generally don't do things that are that require a PhD in chemistry or biochemistry, but a lot of material science, mechanical things, a lot of software, believe it or not. Not exactly the background you would have envisioned for somebody who does a lot of software patents, but it's an interesting field. And software tends to touch on just about everything now. Back in the day, it used to be, oh, you're just patenting some code or whatever, but pretty much everything that has a computer attached to it, which is basically anything you're going to sell or use, probably has software in some. I think that's probably enough.
And the software piece is interesting because it has both the patent and the copyright stuff come up simultaneously,
yes.
Right?
And I'll talk a little bit about how those things play off each other.
Cool. Awesome.
All right, so here's a very rough outline. Like I said, please interrupt or whatever. Fine. So we're going to, like Gwendolyn said, one of the first thing most people think of when you think of intellectual property is patents. There's also other areas there: trademarks, copyrights, trade secrets. We'll talk a little bit about government IP ownership issues. I know that some of what you talked about this morning probably touched on a little bit of that.
Not so much government IP, actually. No.
All right.
So marching rights and things like that. Yeah,
All
we
right.
should definitely.
And
cover
then
that.
Gwendolyn wanted to include a care and feeding of your attorney section. So, we'll put that in there too. So let's just dive right in.
I.e., how to afford working with your attorney.
How to make your attorney like you, which is valuable, because we tend to be nicer to the clients who are nice to us. It's a little quid pro quo. So anyway, just to jump right in, and I'm going to kind of tear through these things relatively quickly, unless somebody wants me to dive in deeply. But anyway, patents are sort of, I kind of broke them out. Patents are what protects how. You get a patent, but a lot of times somebody will say, hey, I want to patent this cool invention I have. It's like, okay, so at the end of the day, what you're going to protect there is how that invention works. What's in it, if it's a composition, if it's sort of a process for generating energy from nuclear waste or whatever else. You're going to go through each of the process steps that get you from starting product to whatever your beneficial output is. Patents are awarded on things that are useful, which seems like it should be obvious, but you're not supposed to be able to get a patent on something that doesn't actually have any use. Sort of threshold testing. And sort of the patent system is set up like here's our constitutional law blurb for the day. Patents are actually established. The patent rights are established in the U.S. Constitution. There's Article 1, Section 8. I think off the top of my head. Basically says that to provide for the development in the useful arts, the Congress will establish laws granting monopolies to inventors. And that's really what a patent is. It's a limited monopoly. Assuming you get a patent issued, it allows you to exclude others from making, using, selling, or importing the patented technology, whether that be a machine or a composition or a process or some combination of those. If you hold a U.S. patent, you can keep somebody else does what's claimed in your patent within the confines of the U.S. or otherwise touching the United States, you can bring suit against them in the U.S. court and say, I have a patent, you shouldn't be able to do this. So that kind of touches on one element of patents, which is they're territorial. So you can get a U.S. patent. Pretty much most countries in the world have some form of patent system. Some of them are ones that I've probably never dealt with and never will, but the large players all have fairly well-established IP regimes. The U.S. continues to be maybe it's just because there's roughly, I don't know, 2 lawyers for every regular person in the United States, but we have a well-established IP litigation system, and therefore your predictability in what you're going to get, your ability to get damages or basically intercede somebody else from infringing your rights is probably greatest here. Second place is probably Germany. After that, it becomes, the rights are nice to have. You can certainly get somebody to maybe take a license from you. Oftentimes it's going to be, I'll pay you a little bit more for that license to your patent in the UK or in China because you've already beaten me on a patent in the US that's related. I'll just buy the worldwide rights and not have to fight with you anymore.
I have a feeling that there'll be some questions later about, where should I be filing besides the U.S. when we kind of talk about strategy and all, where should I really care about? Do I care about Zimbabwe or do I care about Japan?
Yeah. And actually, depending on the technology, certain things the U.S. government won't let you patent anywhere else anyway. There are patent applications that get filed that get locked under a secrecy order. We have a couple of these at the firm where you basically the attorney has to go through a certain security clearance. All the correspondence with the patent office has to be under lock and key. We have to have like a special VPN to communicate with them. It's all very cloak and dagger. Sometimes things get thrown into those bins that make no sense at all, which is really kind of funny. It's amusing because somebody who's probably at GS5 or GS7 at the patent office looks at the application and decides whether it belongs here or there. And things that get misfiled are kind of funny.
The reference to GS there was your government service level goes all the way up to GS15, so GS5 is...
A mid-level clerk whose job is just to spend 5 minutes looking at something and throw it in a bin. So sometimes they end up in the wrong bin, which is fun. So interestingly, or maybe not, patents don't actually give you the right to do anything. They give you the right to stop others from doing things. So sometimes people say, oh, I have a patent, I can go ahead and practice my invention. The fact pattern there is you have a patent that takes some existing process and improves it, adds some new features to it. You can get a patent on that improvement, but somebody may still hold a patent on the underlying process that you've improved. And if practicing the improved process requires doing some aspect of the unimproved process, you may need to take a license to the person who has the earlier patent. And then if they want to do the improved version of the process, they'd have to take a license from you. So that ends up being one of these sort of cross-licensing situations sometimes where the two parties say, okay, rather than sue each other, let's just, you pay me for a certain amount and I pay you a certain amount and we just call it even and we can each do what we want to do. Patents are entirely statutory. There's no common law aspect that's in there just because some of the other IP rights actually come into effect just by use. You don't necessarily have to register to have a trademark or a copyright. Some of those rights spring into existence just because you did something. Patents, you actually have to affirmatively go to the patent office, file a patent application, deal with a patent examiner, sometimes appeal from the patent examiner's decision, and then ultimately get patent issued. And to infringe a patent, you don't actually have to know about it. So there are certain things where there's no willfulness or there's no requirement that you be aware of the patent or that you can say, oh, I didn't know about that, I didn't infringe it. It doesn't matter. If somebody has a patent and you happen to do what's patented or make what's patented, you can still be found to infringe. There is a kicker that if you did know about it and you still infringed it and you're found to have been willful in your infringement, then the damages get tripled and things can get really expensive. So patents generally give you some various benefits. That's why people spend the money to get them. One of them is competitive business advantages. So if you're first to market and you've got patents that surround your technology, then once you start making a lot of money, competitors may want to say, oh, that's a great idea, I should do that as well. So if you have a good patent portfolio around your technology, you've got a reasonable chance of at least making it more difficult for someone else to do what you're doing. Chances are, if there's enough money involved, people's risk appetite becomes greater. So they say, oh yeah, they have a patent portfolio, but let's roll the dice and see what happens later On the flip side, if you're, I get this from clients all the time. So, I want to make sure that I don't get sued. You know, I want to make sure I don't infringe anybody's patents, and I'm not going to get sued on things. And my answer is usually that, well, I can tell you the best way to not get sued is to not make any money. If you are successful and you actually have a growing business, somebody will come out of the woodwork and claim that you infringed their patent or you stole something from them. It's the way of the world. It's good to have a patent. That's one of the reasons it's good to have a patent portfolio of your own, so that when somebody comes at you and says that you're infringing their patents, you can turn around and say, well, then you infringe mine. So it's sort of a mutual assured destruction thing, which that joke's funnier in a non-nuclear situation.
Take it all personally.
So other benefits, you can potentially, if you have patents on technology that either you're using or that maybe is ancillary to what you're doing, you can license them to other companies who might pay you a revenue stream in that way. Cross-licensing is what I mentioned before. Patents, in addition to being able to sue somebody for infringement by filing patent applications which are published, you create prior art that may prevent others from patenting in and around your same technology.
Can you go into a little bit more what the definition of prior art is?
Oh, sure. So, actually, I have a slide that gives that.
Oh, okay.
Just jumping my slide.
Jumping.
So, also, especially for a startup, having typically, if you're taking investment dollars from anybody, one of the check boxes is, do they have patents around their technology? Anyone who's ever watched the Shark Tank, that's one of the first questions they ask. It's like, oh, this is great. What's to keep somebody from rolling right in and doing exactly what you just did? Saying, oh, we have X number of patents filed, we have these issued. We've built ourselves a nice little protective ring so that somebody may yet copy us, but at least then farther down the line when we have more resources to actually try and kill them off, we have some weapons to do so. All right, so here we'll talk about prior art really quickly. So there's multiple statutory requirements for patenting. The first one is whatever you're trying to patent has to be both new and useful. Process, machine, and manufacturer, composition of matter. Judicial exception is in there because recently the Supreme Court has made things complicated, especially in the software and some of the natural products side of things. They've carved out various things that they say are not eligible for patent. So you can't patent an abstract idea. You can patent an application of an abstract idea, but not the abstract idea itself. A lot of this was some backlash to the last 20 years or so of U.S. patent law, where people were able to patent business processes. I know everyone's probably heard of like the Amazon one-click patent. Amazon actually had a patent on the ability to click one button and buy something, which sounds stupid, but they had a patent. And there's several of the cases that went to the Supreme Court were basically sort of computer automated versions of typical financial processes, like an escrow account, doing it on a computer, which sounds like it shouldn't be patentable just because that would be relatively obvious, but the Supreme Court, in its less than infinite wisdom, decided to make this extra test that nobody really understands right now. So
they gave themselves some wiggle room.
Well, as a patent attorney, anytime the Supreme Court decides to wander into patent law, it usually means that everything's going to get really confusing and you'll be fully employed for the next 5 years. So, and if Congress gets in there, it really makes things messy. They're even worse. So, and so once you get past that sort of threshold, like, am I eligible for patenting, then we get into what's prior art. And those are the next two sections, sections 102 and 103. Section 102 basically just says a person is entitled to a patent on their invention as long as it's not already known. So the way that the Patent Office determines whether something's known or not known is they go back to the date that you filed your patent application, and they look at documents, publicly available disclosure documents, either other patents, academic literature, the like, and review that in light of what you've claimed in your patent application. And if what you've claimed sounds too much like what's already been done, they'll say you can't have a patent. They'll come back to the applicant and say, these sound the same. You may be able to fix that by saying, oh, well, I meant something more specific than that, in which case they'll ask you, within your ability to do so, you can try to amend the claims and make it a little more specific, and that may get you over it. The more complicated test, and the one that really smacks of sort of super fuzziness, is inventiveness or non-obviousness. So even if the Patent Office can't find something exactly like what you're claiming, they may say, well, if you took that particular thing and this other thing and you squeezed them together, or modified this one based on that, it all would have been obvious. Somebody of ordinary skill in the art at the time that you filed your patent application would have just thought this was trivial. So it's a very odd test because oftentimes by the time the patent examiner looks at your patent application, it's been 3 years since it was filed, and he or she has to magically transport themselves back in time and pretend like there's somebody who knew nothing about your patent application, and just looked at what was available in the existing literature, and then sort of construct this. Oh, well, if you took this and did this, it would have been obvious. So it's the part of the statute that usually drives inventors the most insane, because they say your patent is rejected because it's obvious. What do you mean it's obvious? It was really hard to make. Blah 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 blah. So sometimes that there are arguments to be made. Sometimes it involves amending the claims, but it's generally speaking, I'd say 95% of the applications that I file end up with the first time the patent office goes back, they say it's obvious.
And we can probably expect that the patent examiners with whom these folks might be interfacing probably have a pretty deep knowledge of all things nuclear.
Yeah, your patent application is assigned to a specific technology group, and so generally speaking, again, subject to the whims of whoever sort of bins the application when it first comes in, generally it's going to be examined by somebody who's got some sort of a background in what it is you're talking about. The patent office they tend to hire sort of undergrad and maybe master's level engineers and scientists, and give them some training. They're not lawyers; they're basically engineers. So they kind of have the same background as patent attorneys, except they usually lack sort of quite as the language skills may not be there. They're sort of more of a
Their social skills might not be there.
well, sometimes you read I can sort of see what you're trying to say, but you didn't say that very well. So let's talk about it and figure out why that's not true. All right, so oftentimes the question is, well, did I invent something? Typically, I mean, I remember when I was in graduate school, I was so sick of my thesis project that I was convinced that nothing in there was brand new and it was all the worst thing I'd ever seen, and I never wanted to do it ever again. That tends to be the same sort of thing that happens. Engineers are notorious for this. They'll work really hard, solve a problem, they're on to the next problem, and they'll be like, oh, it was easy, it wasn't that hard. It's like, well, go back to the problem that you solved and think about it, and think about what the situation was before you solved the problem, and let's reconstruct what you did to get over that hurdle. What you did there may have very well amounted to something that was invented that's worth protecting, especially if you solved a problem that somebody else who follows along with you would have to solve unless you told them how to do it, or unless they saw how you solved it. So if you've gotten to the other side of the hill, don't forget to sort of plant your flag on the hill and say, hey, we got over that, and if you want to come over there, you have to pay us a license or otherwise find a different way around because we've patented that.
And I've had this experience both with nuclear and non-nuclear situations where the team is working on solving a specific problem, but in order to solve that specific problem, they had to develop some tool or device or whatever in order to get at the problem, and then somebody else kind of walks in and goes, wait a minute, you just invented something over there. And we're often so focused on solving our problems that we forget that, like, oh, I just invented this magical device that did this other thing. So sort of have that awareness of that along the way, as Mike was saying, hey, you just finished a project, you just solved a problem, keeping notes in your lab book about what you did.
It's super important early stage in a startup company, because oftentimes everyone's wearing 6 or 7 different hats and probably doing way more than they think is possible. If you look back at it, you're like, how do we do all that stuff? So it's pretty easy to go, oh, we got through that, I don't have time to deal with that, let's just move on. We've solved the problem, it's time to charge forward, but it's a good idea to sort of sit down once in a while and just think, all right, how did we get here, and what did we have to do to get over whatever problems we might have had? The last point is just sort of think about the problem from a number of different angles. Sort of sometimes you might solve a problem and then decide, well, that solution wasn't really, we got a better solution. But the first solution that may give you a maybe less efficient route to something beneficial, you've decided to go another way. Don't forget to maybe file a patent application on that other way, because if you have a good patent on the best way, your competitor may come along and say, oh, well, why don't we go the other, this is not so bad, and then they find out you got a patent on that too, and then they're really stuck. So if they're a big enough company, they may just decide it's rather than trying to fight the patent, they just buy the company. So we've had that happen with some clients where well, this is just too much of a hassle. Now you're suing us, we're suing you. Let's just get this over and done with and pull out the checkbook and solve the problem. So there's basically two routes to get into a patent application. It's sort of over here, the light bulb goes on. You've conceived of an invention. One route there is sort of the it's core to what I'm doing, and in order to sort of take it from the idea to actually making it work, I've built it. So one way to do it is you've actually started doing you've actually started using the invention. That's not actually required to file a patent application. If you've come up with the idea and then you've sat down and thought about how it would actually work, that's called constructive reduction practice. That means I can explain to somebody how to do it without actually having done it. So you don't have to wait until you've started doing it to file an application as long as you've figured out how it would work. That's the time to start talking to your patent attorney.
Now, is that the change with the new patent law, or has that always been the case? Okay.
Okay, so types of patents. There's the first two are actually sort of friends of each other. The provisional application is basically I have a good idea. I think I've figured out how it works. I don't have a whole lot of money. I'd like to get a filing date so that I can prove that I invented this before somebody else. You can write up what's called a provisional application, which is largely a technical description of the invention. It doesn't have to have all the bells and whistles that a regular application has. A regular application is called a utility patent, or utility patent application. That requires a written description, claims, figures, a lot of formula, or a lot of there's a form to it that the patent office wants to see in order to actually examine it. The provisional application, it gives you 1 year from when you file it before you have to file a utility application that claims priority to it. So oftentimes startups will say, look, we don't have this idea fully baked yet. We kind of know what we're doing. Maybe almost always with a startup, the budget is an issue. So we don't have $10,000 or $12,000 or $15,000 to spend on this patent application now. Hopefully, once we get some fundraising done, we'll have that in a year, and we'll kick the can down the road till then. So in the short term, let's spend some small single-digit number of thousands, maybe $4,000 or $5,000, $3,000, depending on how complicated it is, to sit down and just write up as much technical detail as we can, and then we'll figure it out later. The other two types of patents are design patents, which deal with sort of the ornamental view of something. They kind of cross over to trademarks a little bit.
Are there any dangers with just filing the provisional? Like, do you have to end up doing your work twice? Are you going to spend $3,000 to $5,000 and then you're going to spend 10 to 12?
Well, generally speaking, the total amount you're going to spend by filing a provisional and then a later utility application is probably going to be more than if you just filed a utility application. Just because, if nothing else, you've talked to your patent attorney, you've done some work. Your patent attorney has probably done 500 different things between when you file that provisional application and a year later. So there's a little bit of spin-up time that's going to be required. You're doing 2 filings and 2 just interfacing with that process. But you get to push at least some decent chunk of it off by a little bit. Sure, go ahead.
How exactly do you quantify the price behind a utility patent?
It's largely how long it takes to do it and the rate that your patent attorney charges. So it's pretty much just like building a house. It's going to take X amount of time, and I probably charge slightly more than the guy who built your house. But I don't know. It's
sending the actual application, price-wise.
Oh, the filing fee, you mean with it? So the filing fee with the patent office, especially the U.S. patent office, is a relative bargain. So if you're a small company, less than 500 employees, the filing fee is $800. So most of what you're spending on the initial filing of an application is probably with your attorney. I don't know. You can certainly make a deal with your attorney and say, I don't want to spend more than $8,000 on a patent application. You'll get an $8,000 patent application. Generally, it varies by attorney, but by and large, you're probably not going to find somebody who's going to do a good patent application for less than sort of high single digits. And the price kind of scales with complexity. If you've got, sometimes the patent application might actually, for various strategic reasons, describe more than one actual invention. So there may be, somebody may have just wanted to kludge it all into one giant document with the idea that you'll get a patent on one part of it and then you'll refile it and get a patent on some other stuff. It kind of all just comes down to what your comfort level is. I will say that I've seen a graphic that it's a pie chart that visualizes sort of the amount that you spend on the various parts of the patenting process. And if you've got a patent application that you're maybe going to file in the U.S. and potentially Europe, China, a few other large foreign countries, And then you add up sort of the amount that was spent on drafting the application and with dealing with the various patent offices, and then the fairly sizable and escalating fees to keep the patents in force after you've got them issued. That pie chart probably totals up to about $250,000 over a 20-year period. Of that $250,000, the part that you're paying your patent attorney to write the application at the front end is, I don't know, maybe 15 if it's a fairly expensive one. However, the $5,000 application that you get from the bargain basement patent attorney will probably cause either the patent not to be all that great or a lot more extra work to be done dealing with sort of what happens in the other countries.
And then do you end up doing, is some of your practice kind of mopping up the problems where other perhaps cheaper, lesser attorneys
I do some
mopped
mopping.
it up?
I'm a fixer sometimes.
Uh-huh.
I mean, I have a lot of clients that deal internationally, so there's slightly different set of requirements in the U.S. versus elsewhere. The U.S. is more permissive in certain things that you can get away with that you can't in Europe, and then vice versa. So it's kind of, you have to write a document that maybe addresses as many of those potential issues as possible, and usually comes out, I don't know. I think I'm a bargain, but some people might disagree.
Sounds hard to do it oneself, but you're going into the contents of a patent application right now.
Yeah, there you go. So these are the three main sections of a patent application: the specification, the figures, and the claims. So the specification looks very much like a technical paper. It's going to be a description that says, this is probably laid out in some sort of a form that says, here's the problem we're solving, and here's how we solved it. Sometimes, if it's well done, it may have a few potential solutions to the problem. But at the end of the day, it reads, probably sounds, to somebody who doesn't read a lot of patents, it'll sound somewhat repetitive because there's some sections within the specification that are kind of redundant with each other. That's actually by design. It's not just because we're trying to make our term paper look longer by copying everything over and over again. Then the figures are basically referred to by the description will refer back to the figures and use it to illustrate certain things. It is, in the U.S. at least, a picture is actually worth 1,000 words at least. There's case law where U.S. applications have relied entirely, or an applicant has relied entirely on a figure to support their claims that were filed later. That doesn't fly in most of the rest of the world, especially Europe, China, Japan, are much more literal. And the reason for this sort of needing for disclosure is, I mentioned before that you'll get your prior art rejection or some other rejection from the patent office, and they'll say, your claims are too broad, your claims sound like this other thing, and you need to kind of try and tighten up the claim language, make it a little more narrow. You can only do that to the extent that you can show that you had that thought at the time you filed the application. You can't come along later and say, oh, no, I meant this when I described this big fuzzy thing. So having that extra description in various levels of granularity and detail in the application is key, because otherwise you may come along and the patent office says, well, we're not buying your claim language now, and you're stuck because there's nothing else you can do. Go ahead.
How do you really know that you're not infringing upon someone else's application? Because, like, I would say, we're working with my lawyer right now, that he knows probably less about like other patents that could be infringing on this than I do.
That's almost certainly the case. If your patent attorney is an expert in what you're trying to patent, chances are it's not new. I mean, you guys are the smart guys, so I mean we're smart at what we do, and I like to think I'm good enough at asking enough questions to not sound like an idiot within 5 or 10 minutes of talking to you, as long as the technology is not completely out of my realm, and I've got a pretty good base. But generally our job is to ask you a lot of questions. If you're aware of other things in the space, it's good to share them with us, because when we're writing up the description, if you tell us, these things are, this is stuff that's already been done. You really, when you're writing a patent application, that lengthy description, it's kind of like when if you write an academic paper, and you end up, I get this sometimes from folks who are clearly academics, they end up with like this 25-page background section. It's explaining everything they know about the prior art. Like, that's boring. You haven't spent any time explaining what the actual interesting part of the application is. You're burying the lead down at the end. So my background section usually looks about that long. It's like a paragraph that says, here's maybe a broad statement of problem, and then let's talk about what's new and interesting. You're under no obligation to explain everything that's ever been done before. The Patent Office will do its own search. If you're aware of references that are interesting or relevant to what you're trying to patent, you need to provide them to the U.S. Patent Office. They rely on that to some. If you don't do that, you can actually end up with your patent being invalidated for inequitable conduct. But yeah, your patent attorney's job is to talk to you and find out what was the problem, what are the other ways people have done it, and how did I go from what other people were doing to what solved the problem.
But you're making, go ahead.
But there's like no index or something that.
Well, there's plenty of indexes. I mean, there's one, you've got one on probably on your iPhone right now. It's called Google. And you can search the Patent Office for previously filed applications. The catch there is if you're in a fast-moving field, a patent application that's filed today will not, absent some request to publish it early, will not get published for 18 months. So there's a year and a half lag time between when somebody might file an application and when you'll find out about it. So to some extent, and you asked infringement's another issue. So you can try to solve an infringement issue by doing some searches and saying, okay, let's see what else is out there. There are search services that do that.
Sorry, one more question.
Sure.
So if I file for my provisional patent application, and I take exactly 1 year to do it, but in that time, someone has already taken my idea and filed for the utility, but my provisional utility didn't get filed until after that. What are my protections?
Well, assuming that the invention that you're claiming in your utility application was described in sufficient detail in your provisional application, you are entitled to the filing date of the provisional application for the utility. That's the 1 year period. As long as you file within a year, you get to jump back in time a year to when you filed the provisional. So if those two applications, if in that fact pattern those applications get examined, under current patent law, you win. Before the patent laws changed about three and a half years ago, the U.S. was a first to invent system. So if you end up with a situation like that, they would go to this very complicated, very arcane hearing and almost like a little mini trial. So the filing date wasn't controlling, it was when you actually invented it, which is just a giant mess. It would require going back to everyone's lab notebooks and witnesses. And now it's, if you were the first one to file it, then you win. Unless the other side can prove that you effectively stole it from them. Like if you filed something based on a derivation of what they shared with you, then you lose. But otherwise, yeah, that's it.
Thank you.
You're welcome.
But I did want to bring up one point. You made a distinction between your background section for the submission for the application being quite short, but yet so don't waste your time disclosing background to PTO. But when you're having the conversation with your attorney, yes, do go in and educate him or her.
Yeah,
so difference in like the amount of background information.
Right. Yeah. I mean, I may not put it all in there, but the more I know about what you're doing, what's been done before, the better off I'm going to be. Go ahead.
So, Gwendolyn, you had mentioned earlier that if your patent's going to last for 20 years and you're not going to be building something for 15, then there's less incentive to file now. You should maybe wait and just try to keep it a secret. So
it actually, I should just say this, it actually wasn't I who said that, it was Alex, because I'm not an attorney, I can't give legal advice. But at some point we were going to be talking about patent strategy and sort of when to keep something trade secret, and knowing that a patent has a certain lifespan, and nuclear is a little different from plain old solar and wind as well as IT. We've got some long lead times to market. So I think that's your question, right? How do you manage kind of the long lead time with some of the stuff in nuclear with the more limited time that perhaps a patent might apply? Is that kind of your question?
I guess there was two parts to the question.
Okay.
That basically is the first part. The second part would be, is it advisable to have a patent lawyer from the beginning, so that does a patent lawyer advise on that kind of thing as well? It's not just
a good one does. Yeah, I mean, our job is not to just turn the crank and file a patent application for no reason. I mean, part of the job is figuring out what's the best way to make sure that the company comes out of this whole process with a robust and defendable patent portfolio. And to your question about sort of keeping it secret, that is a potential strategy. The risk, if you start using the process even secretly, under US law, which is not terribly well settled, that may amount to creating your own prior art. There's actually some historical case law that if you're using something totally in secret, but gaining some commercial benefit from it, but then 10 years down the line you decide, okay, now it's time to patent it, that secret use can actually amount to patent defeating prior art. That case law is kind of mushy at the moment. Not in no small part due to the fact that the America Invents Act was written, looks like it was written by lobbyists. It's the one of these sloppier statutes I've ever read. From section 1 that talks about the actual law to the exceptions section that follows immediately, if you read it, it's like word salad. These words don't match these words, and you go, I don't know what happened. So
And America Invents is what we've been referring to as the new patent
yeah,
law.
that went into effect the final parts of it went into effect in March of 2013. So, and that was the official transition there was from a first to invent to a first to file system. Our old system, because it was first to invent, had a bunch of sort of windows of time when things that the inventor did would not defeat the inventor's own patent. So you could file something up to a year from when you first disclosed it, and you could still, because your disclosure, you could have like an academic paper published on January 1st of 2012, and then file a patent application on January 1st of 2013, and you would still, your paper would not amount to patent defeating prior art. As a matter of fact, it would defeat everyone else's patent, and it would let you show your invention as of that date. So if somebody else even invented something and filed it before you could go back and say, well, look, unless you can predate my paper, I had the invention here. That's been done away with. Those public disclosure events by inventors and other people associated with the inventor, meaning like the company that the patent's assigned to or whatever else, still don't amount to actual patent defeating prior art. However, they don't stop the fact pattern there where I file something on I publish a paper on January 1st, 2015, and then I file my patent application on January 1st, 2016. If somebody else filed a patent application in between my paper and my filing, their patent application is going to defeat my patent application. My paper publication is going to defeat their patent application, so nobody wins. Everybody has prior art against them, they're all toast. The only way that you potentially win in that situation is if you prove that their filing was entirely derived from your earlier publication. So as long as they have some sort of lab notebooks that say, no, we're working on this, and we noticed that you published this paper, so we thought perhaps we should file a patent application. And it had nothing to do with you. The outcome there is different than it used to be.
And does the new patent law put us more in line with the international community or less in line with the international community?
We still do whatever the heck we want. I mean, we're closer. The rest of the world has been on a first to file forever. However, most of the rest of the world operates on an absolute novelty basis, and we still have all these weird exceptions that are sort of left over from our previous code. So in Europe, if a professor publishes a paper on today and files a patent application tomorrow, you're done. You've given away everything, and you can't get any of it back. You can still file in the U.S., but in Europe you'd be toast. Yes.
So if I find, I file the utility application, finalize that, and I find along the road that there was something that I was missing in my design that needs to be incorporated, do I file a new patent? Do I have to amend it? So what's the process for that?
Amending it would be a challenge. So I guess the follow-up question is that something missing essential to actually making it work, or just some extra feature that you forgot to describe?
Let's just assume, not that this is happening to me right now, but let's just assume that it's someone else could very well use it, and it would invalidate my previous design. And would I file an entire new application?
Probably. I mean, it's assuming that chunk that you omitted from the previous one amounts to some inventive value on its own. I mean, if it's new and non-obvious, it's hard to know if it's obvious or not. I guess everybody knows. The test for obviousness sounds an awful lot like the Supreme Court's old test for obscenity. It's like they sort of, I know it when I see it, and then try to argue with that. And the patent examiners are even worse than that. They just, like I said, they pick a bunch of references, throw a bunch of stuff together, and say, there, obvious. So, no, not really. Okay, so figures, I did that. So claims, the claims are the end part of the application. They're basically the entirety of the they're the virtual fence that you draw around your invention. So the claims are English or something that looks like English. They're English words assembled in a very strange looking way that effectively delineate what is included in your invention and what isn't. And so the Patent Office uses those claims to figure out whether what you've defined in those words sounds like the prior art, and if it sounds too much like it, then they'll reject it. And then eventually, if you can converge to some language that the Patent Office agrees is patentable, those same claims then define the scope of what is protected. So when if you accuse somebody of infringing your patent, for them to, your claim is basically a list of stuff, elements, process steps, pieces or whatever. For somebody to be found to infringe that patent claim, you have to be able to show that whatever it is they're doing checks every box for every element that's in your claim. So if you have a claim that has, say, 5 elements, A, B, C, D, and E, if I find a competitor who's doing something that sounds like exactly what I'm doing, and you show them your patent claim, and you say, well, that's all well and good, except I don't do E, I do F instead. That even though they do A, B, C, and D, if they don't do E, they're not infringing. So you have to, it means there's a bit of a tension there in your patent claim. The longer your claim is, the more elements it has in it, the easier it is to distinguish over the prior art, because the examiner has to find all that stuff in the prior art somewhere. On the flip side, to exert that patent against somebody, the infringer has to do all the elements that are in the thing. So longer claim equals easier to get patented, but harder to maybe fit an infringer into what you claim. And that's kind of goes to this best to have you get more than one claim. You can file 20 claims in the US with your filing fee, and you can pay extra for more if you want. But typically the claims start with sort of a relatively shorter version, and then we have things called dependent claims that say, well, everything that's in claim 1 plus a little bit more, plus a little bit more, plus a little bit more. And the idea is somewhere in there I've got something that's both patentable and potentially valuable as far as getting somebody for infringement.
And the dependent claims are on the same application, or are they on a subset?
On the same. So sort of the process of getting we talked about this a little bit, but getting from I have an idea that I think might be patentable to getting it patented involves sort of putting together your disclosure materials. This can be flowcharts, figures, some sort of an explanation about what it does, how it does it. I get these in all sorts of flavors. Big clients that in-house patent attorneys usually have a very formulaic invention disclosure form the inventors have to fill out. They also usually have some sort of incentive program that says if you file a patent application, you get $2,000 or something like that, which means they get lots of disclosures because engineers like to get extra money. Others, startups tend to be a little bit less formal in that regard. Sometimes it's just, hey, why don't you come on over and bring your iPhone and we're going to whiteboard this thing and you're going to take some pictures and take a bunch of notes and write up an application. Those tend to be more expensive, just because if you give me something pre-written that at least goes through has the verbiage and the language that you want to use, I've got to clean it up and make it sound like a patent application instead of just building it from whole cloth. Also, the identification of known prior art, that kind of goes to your question. It's just whatever you know about, you should probably tell your patent attorney about. Nothing more fun than having the meeting, doing the whole discussion, writing up the application, and then the inventor's like, oh yeah, by the way, there was this reference that I didn't tell you about before. Okay, so now we get to rewrite this because what I claimed sounds exactly like that. And then, as trivial as it sounds, deciding who the inventors are is kind of important. So inventors. That's important, first of all. So somebody who's an inventor is somebody who contributed to the conception of some aspect that's claimed in the invention, or in the application. That tends to be kind of a fuzzy test, because what if you got like 5 people sitting around a table throwing ideas at a whiteboard, and we come up with something. It's like, well, who actually contributed? Who was just in the room? Who was laying the groundwork? Especially for a startup company, I tend to be a little over-inclusive. If you were there and there's some reasonable chance that you did some sort of contribution, even if you just sort of threw an idea out that somebody else turned right, probably better to list that person as an inventor, have them sign a declaration saying they're an inventor, and more importantly, have them sign an assignment that says, I assign my rights in this invention to the company. Worst thing to happen is somebody who may have arguably been an inventor isn't listed as an inventor, never signs the assignment. Goes to another company, possibly a competitor, your patent issues 5 years later, you turn around and try and sue that other company for infringing your patent. They say, well, that's great, but we actually, one of the inventors on that is our person, and you forgot to add them. So your patent's either invalid, or this person should be added as an inventor, and they work for us, so we own part of the patent.
What if one of the inventors signs into the company and then decides on legal paper? Does the company still own rights?
Company still owns it, yeah.
Okay.
Patent rights are fully transferable. There's no, copyrights have a little, I thought, like a moral right that you can you can keep the distribution rights separately, but patents don't.
So I've been waiting to ask this, but very woefully ignorant on this topic, and I probably shouldn't be, but the IP relationship between students, researchers, and universities.
Yeah,
Could you
actually,
break
that's
that
what we were
down?
going, I was hoping we
Because
would go next.
I have no idea.
Yeah,
and
can you talk to us about students and Weidler and Bidor? Do you have,
I have
are we going into that later?
I just had bullet points that we could mumble about later, but I can talk to you about right now. So generally speaking, especially in California, whether you're at a university or anywhere else, if you are an employee of the company and you are what is called hired to invent, meaning probably everyone in this room probably qualifies. Like if you're a smart person whose job it is to, make stuff, or you're an engineer, if you're not, like if you're a janitor, you're probably not hired to invent. So I'm assuming you're not a janitor. But those, under California law, those people are basically assumed that anything they invent belongs to the company. There are ways to carve that out if you say, I'm inventing something that has nothing to do with the company's business. I used only my own equipment. I didn't use any of the company's equipment. And California's law is maybe a little bit more restrictive in that regard than the rest of the country, but not by much. Typically, you probably sign something, you're at Berkeley, or
Mhm.
yeah, so I'm almost certain that if you sign something that said, here are the things that I believe are my own inventions that pre-existed before I showed up, and most people don't put anything there. If you are presented with a form like that and you do have some stuff that you are working on in your garage or whatever else, you probably put it down.
Is that a form that comes with like registration, or when they hire
Probably
you
when you
on
get
the
hired as a research assistant, or are you a grad student or
undergrad?
If you're undergrad, you probably haven't signed it yet.
There's no real like hiring process.
No.
You
If
know, I just basically-
you're not an employee, it's only when you're an
Then
employee.
you're not an
Yeah.
employee.
Okay. So, but then what if I receive funding through like?
If you're working in a lab and some part of, if you're working on a funded invention,
Or
there's
even
all
just
kinds of
general
layers.
funding for-
Chances are that
I don't know. It's just
when you start working in a lab, if you're paid at all,
okay.
you're going to get, they probably would give you something to sign. If you sort of, you're at your Chem 1A or, whatever, some chemistry class or engineering class, and you fiddle with something and come up with an invention and you have no ties to the university other than as a paying student, you might have to, probably do. But if you're a grad student or a research assistant or certainly a professor.
Or definitely anything you publish, right? Or
Well, if you publish it in, so if you
You work
write a
on a
paper and
paper.
your thesis advisor or whoever is your author one, the person who's got the grant is the last person on the list, and then there's a bunch of people in the middle. You're typically, those people are all going to have an assignment requirement. If it's your unique work and you didn't, it kind of boils down to whether or not there was government funding or some other kind of funding. There may be some of that.
Or who's paying for the lab?
Yeah, who's paying for the lab?
In which you discovered it?
It gets kind of, it's a student who isn't compensated for their invention kind of is in that weird gray zone.
And then do you buy the IP from them if you wanted to then go start a company?
If
with
there's
that, or what
no
is that?
well, so
How does that work?
the UCs and most other big research universities have technology transfer offices. We're actually, the UC Regents are a client of our firm. We work for UCSD. I think we do a little bit at Berkeley, UCLA, most of the campuses. We effectively, so somebody within the system comes up with something, they go to the technology transfer office and say, hey, we want to get this filed. The technology transfer office goes to a patent attorney and says, write this up, we want to file it, we file it. All the rights get assigned to the university. Those offices exist entirely to spin that out, because UCs don't want to they don't want to sue anybody, they want to license it. We're spending X amount of money to get this thing written, we want somebody to take it and commercialize it and pay us a royalty. That's the whole
So
business.
they get
model.
like equity and
Yeah, there's usually, the UCs that I've worked with have, there's like an A, B, and C license. And it's a sliding scale between how much you're paying in cash versus how much equity you're giving up. So you have less cash, you're going to give up more equity. You want to pay more up front and maybe give up less equity. I get all kinds of complaints like, oh, this is terrible. It's such a, they've got me over a barrel. It's like, well, it is what it is.
Go start your own research university.
Exactly. So, the UC regents do not exist to give everything away for free. So.
Two questions, maybe they can be answered in combination. One is, what if I'm here to work on a nuclear reactor and I want to design a new coffee cup in the meantime, or while I'm here at the same time? Do I have to do that on a computer not provided to me by the university in my own home?
Probably be a good idea.
Okay.
I would advise it.
Second question is,
Same if you're working for the government or a company.
okay, so that's sort of
Generally.
the next question, is if I'm not funded by Berkeley, I mean, I guess that's still their computer, they're offering me the lab, but then there's no designated workplace per se. So how do I, because also fellowships tend to not be so specific about the work scope.
Yeah, it's a gray fuzzy area. It's very fact pattern specific. I guess to give you a total a lawyer non-answer, but yeah, it's consult your attorney. Yeah, that comes down to sort of how the facts play out. I mean, all you can do, and frankly, most things in this area don't have a definitive answer.
It's how the facts play out, but what might be some of the indicators? Like I was doing it on my own
Yeah, if
computer,
I
I was funded by a fellowship or not, or.
Yeah, I mean, a fellowship is kind of a fuzzy, it depends on who the fellowship's from. If it's a government fellowship, the government's probably going to think that, we paid for your brain and stuff like that belongs to us. If the fellowship is very targeted, it's a fellowship to do nuclear research and in that coffee cup, you can probably say, come on, I'm not, you don't own a coffee cup. And actually, government funding is not quite as, a lot of people complain about it, but what generally happens in those situations is the government takes a royalty-free license to the IP. So it's not, that means they can, and it's not transferable. Other than they can send it to a contractor to build something or whatever else, but you're not going
Within
to
a government field of use kind of thing.
They can't just turn around and then sell us your biggest competitor. Yes.
So when the government takes a royalty, who is that going to? What part
Well, they're
of the
taking a royalty.
government?
They got a license.
Or
A license means they can practice the patented invention
As
without
well.
paying you a royalty. So the UC regents they take some sort of payment that gets rolled back into retrofitting buildings and all kinds of other fun stuff. So just kind of a quick run through here. It's like we've talked about parts of these. You tend to provide some sort of documentation or description that may very well be scribbled in real time on pieces of paper, on a whiteboard. Maybe it's a PowerPoint deck, something else. Oftentimes the attorney will get involved, depending on how well planned everything is. And with a startup, it tends to be like everything's today's emergency. It's like, hey, we're about to go make this presentation to this, potential customer. What are you showing them? Oh, all this other stuff. Have I ever seen it before? No. Okay, so we're going to need to sit you down, send us everything you've got. We may file. That's a time that I'll tend to use a provisional application because I might get this whole download of stuff. It's like I've got limited amount of time to sift through it. I got to make sure. Might even file the PowerPoint deck as an appendix just to say, look, we have it. We're going to go back and clean that up with something more formal quickly, but I want to basically show that anything that's being shown on the screen outside of the sort of protected secret zone it has a filing date prior.
And this might very well come up in the university setting, say if one of you is headed off to Zurich or whatever tomorrow to go speak at a conference and you forgot to speak with your tech transfer office, they might have something to say about it.
Yeah, tech transfer offices tend to be a good source of adrenaline rushes. Hey, professor just told us he's in China and he's about to present this tomorrow. Can you file? Sure. Anyway, so you get whatever the disclosure amounts to, talk it over with the attorney, maybe 1 or 2 meetings, depends on how much. They're going to usually make a draft of the application, give it to the inventors, they're going to review it, we're going to talk some more. Hopefully we're going to iterate down to some agreed upon accurate description and some claims that we think a good attorney will walk through the claims with the inventors. Even though that's painful as all get out, most people who aren't patent attorneys look at the claims at the end of a patent application and go, can you just tell me what this means because I can't even read this, it hurts. But it's important to kind of walk through and say, okay, so here's what this means. If you were, what I usually ask as I'm toward that end is, all right, so I just showed you this now. Pretend you're your competitor, and I told you couldn't solve this problem doing that. Tell me how else you would do it. And that sometimes ends up with, oh, we could do this thing, and well, we should probably describe that, and possibly claim it as well, because we want to make sure that your patent has as many obstructions to your competitors coming along and following in your footsteps as possible. Then there's some formal stuff, a declaration that I mentioned before, the assignment to the company, and then we file the application. Then we sit around and wait. The patent office is getting better. There was a period of time where pretty much every application I would tell people just don't even plan on seeing anything for 3 years. They've hired a lot of examiners in the last couple of years.
Especially in the energy space,
Yeah.
doesn't it seem?
Not getting office action. You get a first response from the patent office usually in something like a year to a year and a half now. There are certain technology areas that are really, really impacted that just they still have really long waits, but most places don't so much. Yes?
To add on to like nuclear stuff, you actually get a really fast reply from the Atomic Energy Commission that says like, hey, we got it, we're gonna look into it. So
But that's usually the analysis to decide whether everything's going to go into the secret stack, right?
Yeah, I got it like within like 2 months.
Cool.
And there's also, the U.S. has a foreign filing license requirement set up largely for sensitive technologies. So if the invention occurred in the United States, you are not allowed to file that application outside the United States until you've told the patent office about it and it's gone through the review.
That seems pretty important for this group to know.
Yeah, this is the kind of group where that matters. I mean,
Yeah.
if you screw up on the app that lets you do 150 characters instead of 140, nobody's going to care. But if it's nuclear technology or
Twitter
encryption or anything like that, those tend to get a little bit more scrutiny. And, radar, anything that's got a military application, an energy application, especially energy that can be converted into a military application very quickly, tends to get the hackers up pretty quick. So anyway, what you'll get from the patent office, like I mentioned before, is almost always a no. They usually freak out. Despite me, I'll remind my clients that 2 years ago I told you were going to get a no, right? And you get the reply email, what does this mean? It means we're going to sit down and roll up our sleeves and figure out how to get around it. But yeah, so usually you get that, and then hopefully within 1, 2, maybe 3 iterations, you'll get to something. It may not be exactly what you want. Sometimes you say, well, this isn't the best patent, but it's what I can get right now. There's some mechanisms for continuing to fight. You can say, okay, I agree, we'll take that, and we're going to sort of keep arguing about it and maybe try and get some scope of claims that's a little bit better than.
And how does this negotiation happen with PTO? Are you on the phone with them? Is this happening over email?
Well, it can happen all by
Formal
writing.
submissions?
Everything has to be conducted officially everything has to be conducted by paper. So even if you talk to the examiner by phone, you have to file some formal follow-up. However, especially in the U.S., that requirement, you still have to file something. I mean, you can talk to the examiner, have an hour-long conversation about, let's talk about this, let's do this. Your summary of that interview is supposed to be filed. Some of the summaries are, we discussed the rejections under Section 103, agreed that the prior art does not teach A, and the claims have been amended accordingly. Next thing you get is an allowance. Sometimes it's just, we talked about it a little bit, and we agreed that the claims are allowable. So sometimes it's a little bit of something magical happens there when you're talking to the examiners. And it's much more effective to talk to them. It's otherwise the cycle is very slow. The patent office will mail an office action. You have 3 months, which can be extendable to 6 months to reply. When they get your reply, they have 4.5 months to turn around and send something back to you. So you can do this we're going to talk. It's like having a phone conversation where I leave you a voicemail and then you reply to it 6 months later, and try to do that in that level of asynchronicity with everything else that's going on. It's kind of hard to get things done. So it's especially when you get sometimes your first thing, you look at the prior art and you're like, wow, this is really, really close. We need to go back and figure out what we can do to fix the claims, and maybe there's no point in having a conversation then. But if you're in that sort of zone where the examiner's seeing things one way and you're seeing them another, having a conversation to kind of walk through why they should agree with you instead of keeping to their idea, it can be useful. Go ahead.
So in the context of this bootcamp, let's say someone has come up with something and invented it. Well, at the end of this bootcamp, one of the judges could just say to us, well, what's to stop anyone else from just doing this right now? Okay, so us, being on video and giving this pitch, is that the same as publishing? Is that publicly?
Actually, it doesn't even have to be video. Being in a room and talking to a bunch of people who are under NDA is a public disclosure. I'll have business cards later. Yes?
I have two questions. Given that we're entering a technology age where everything's so easy to do, could there not be a way to speed up the process? I mean, on the
You
top of
would
my head,
think.
I'm just thinking, like, when I hand in an assignment for example, my final year assignment, it goes through plagiarism software and it actually notes all the pieces. I'm just wondering if there's any software that can be produced to, like, streamline the approach a little bit
How
more.
to fix PTO?
Yeah, that kind of stuff. Like, because,
Uh-huh.
you know, it's similar, software that identifies stuff.
Just as an indication of how rapidly the Patent Office adopts new technology, the portal via which patent practitioners, patent attorneys and agents can communicate with them and file things involves probably the worst Java encryption interface I've ever seen in my entire life.
So it does need improving.
That's been in place for like 7 or 8 years. They've never fixed it. Every single time Java gets updated, it breaks. Somebody has to go fix it, and it's awful. So I would like to say that we're 4 or 5 years away from some AI process getting all the way to like right there, but don't hold your breath.
Okay, and the second question is, what's the funding structure for people who actually work in the patent office? Like, obviously,
They
if
get
I
pretty
file
well
a
paid.
patent, I pay you as the patent office, but then are you government funded as well, or is it?
You mean so you get when you work with a patent attorney, there's a bill that I send you that's for my services,
Mhm.
and then there's a small portion that we collect from you and then pay the patent office
Right, okay.
for the filing fees. The patent office is one of 2 government agencies that runs a surplus. The other one is the IRS. So the patent office actually takes in more money than they spend on examiners, which aggravates people in my field to no end. It's like you're taking all this money, you should be using it to actually invest in doing this job better. But
Improve
So
your
they're
own
not a
structure.
not-for-profit.
It's not
they're
their-
not a not-for-profit. It's
no, they're a government agency that
Oh,
just
okay.
they collect more in fees than they spend, and Congress uses them as it's not a hugely lucrative source of funding, but that money gets diverted to other places.
And those funds just go into the general treasury, they're
Yeah.
not like, marked for, childhood education. or
Yeah,
anything
No,
like
okay.
that.
they get
Um,
sponged up.
However, the PTO does have a giant new gleaming glass
Oh, it's nice.
building in Alexandria, Virginia, right across the river from Washington, D.C. But oddly, not a lot of PTO examiners work there. I understand there's like a giant
They have a big telecommuting program.
that giant telecommuting program. So I actually see that as pretty unfortunate. So sure, they're not wasting time commuting to Washington, D.C. on our metro that just shut it down. But instead they're sitting at home, not burning fossil fuels by commuting to work. But on the other hand, they're not having that convivial, hang out around the water cooler, let's go grab some coffee. Oh, what are the ones you working on? They're missing that, that synergistic conversation. So I actually think it's a negative thing that the telecommuting at PTO now.
Yeah, but you could argue that in pretty much any.
You could argue that in any government.
Or any even non-government
Yes.
setting. It's like everyone stays in their pajamas and works from home.
Yes,
There's not a whole lot.
it's a boon for the pajama industry.
Well, no, I suit up. Suit up. Something like that.
Yeah, from here
Well,
on.
thank you.
Cool, thanks.
All right, so once you finally get through that whole process and get the patent to issue, they collect an extra fee from you called the issue fee. A month and a half later, the patent issues. Then, assuming you have products on the market that actually use the patented technology, you need to actually label your patents in that way. A couple of years ago, they actually changed the law, so you no longer had to etch them onto like the metal or something of the product. You could actually just have a URL, and then isn't technology awesome? You go to a website that just says these these products are covered by these patents. So it was easier to update. You didn't have to retool every time you got a new patent. And then enforcement. Some companies just keep their patents and use them entirely defensively. Like we're not going to. I have clients that collect them and never have sued on them other than to cross sue if somebody comes at them. Other companies that are growing are probably they're doing a good job of building a sort of what I would consider to be sort of a bunch of not concentric circles, but a bunch of little areas that they've protected, hopefully around their core technology, so that if somebody comes along and decides that what they're doing is really great, they either have to take a license, get sued, or more likely just buy them because they're small enough that it would just be easier to buy. They aren't quite as dense, or at least maybe it's just because I'm not a trademark, copyright, or trade secret lawyer by primary emphasis, but I have one slide each on trademarks, copyrights, and trade secrets. So they're somewhat easy, the construct's easier to explain. So a trademark is really about protecting the branding. So trademark is some word that it can't really be descriptive. It needs to be sort of a fanciful sounding or just not. You shouldn't hear the word and immediately, without knowing what the product is, know what the product is. So, for instance, I can't get a trademark on a type of table by calling it a table. And there's some tests for whether or not you can get something allowed in that regard. Don't get me started on how Apple was able to get a trademark on the pencil. I would think a pencil seems somewhat suggestive of a stylus, but they're Apple, so they can get all kinds of things done. Anyway, so it's basically some sort of recognizable word or phrase, design, expression, something like that. So it can be a logo, it can be some words, it can be a phrase. Like Coke, it's the real thing. It's the real thing is trademarked. Coke is trademarked. The logo is trademarked. The red can is trademarked.
So in this field, we would imagine that like our company names.
Yeah, it typically.
Or if we had a cool snazzy name for our reactor or
Yeah.
our process or our fuel. or
So the
something.
idea is it's something that's associated. So you say like an IBM computer or Microsoft word processing. Technically, the trademark is supposed to not be it's the actual label attached to the thing.
Uh-huh.
So
Like Intel Inside.
yeah, well, you could say Intel microprocessors. You wouldn't just say Intel. There's instances of crossover. Like if you don't
Okay.
police your trademark really well, if the trademark term is so widely used that it lapses into a descriptive term, you tend to lose it. So Kleenex. I mean, people don't say facial tissues; they say Kleenex. You guys maybe are too young, but back in the day, if you wanted to make a photocopy, you make a Xerox. Even though there was the Xerox brand copy machines or Kodak and whatever else, but Xerox was ubiquitous and everyone just called it Xerox.
Polaroid.
What's that?
Polaroid.
Polaroid.
Polaroids, exactly. So a lot of big companies will have departments entirely whose job it is to go on social media, police the internet, Google everywhere, and just make sure that people are using the trademark term the right way. Because if they don't, then it tends to lose its value. So trademarks, unlike patents, can last forever as long as you continue to use them in a commercial setting. So like Coke has been a trademark of the Coca-Cola Corporation forever, or at least since the late 1880s when somebody decided that some cocaine extract meant a good cola. Let me see what else we got here. So you can license a trademark. Go ahead.
So, to borrow a word from our friends the Brits, we have our fake company name is crowdsource because we're taking dosage data from a large group of people. Obviously that exists in various forms and is used as a verb. Is there any way to keep another nuclear technology company from having that same name?
Yeah. I mean, to me, so the test for whether or not you can use, a lot of things that are trademarked are regular words. It doesn't have to be a total made-up word. A lot of the Silicon Valley startups you hear, they just, somebody sits there and I'm sure they pay some consultants tens of thousands of dollars to come up with some weird sounding word that sort of sounds like what they're doing, but not exactly. But it doesn't have to be. It can be just a regular word. Facebook the word itself isn't anything, but Facebook, a real word, you just punch them together. So the test for whether or not you can actually use or register a trademark would be, it just has to, there's categories. It can be totally fanciful, meaning you just made it up. It can be a regular word that's doesn't really indicate what it is that you're doing, and then those are sort of on the safe side. If it's a word that would suggest to somebody what the product or the company does, just from the term, you probably are going to have a tough time. And then there's other ones where it's just flat out descriptive, in which case you're not. So somewhere on that dividing line between suggestive and not suggestive, you're okay. So crowdsourcing for collecting nuclear reactor data or whatever, it's possible. And the way to keep somebody else from using it is to either, if you haven't started doing anything commercially yet, you may have to file a trademark registration with an intent to use. An intent to use you can extend that out for 2 years. So you don't want to do it too early, because if you're not going to be doing anything commercial for 5 years out, you're going to pay a lot of fees. You're not going to be able to file any more intent to use extensions, and you're going to start all over. But there are some ways to stop others from using it. Yes?
When do trademarks expire?
No, as long as you're using it commercially, they do not.
Okay.
So,
So like the kiwi?
the what?
That was patented.
The what?
Kiwi.
The fruit?
Yeah, it used to be called Chinese gooseberry.
Oh.
They rebranded it as Kiwi and.
I've learned two things today.
I didn't know that. Wow.
Like, when does it stop?
As long as people are still using kiwi as a descriptive, or non-descriptive labeling term for a particular type of
How
fruit.
can you trademark a fruit? Like, you didn't invent the fruit. You just
Well,
grow it.
the issue though is that's probably lapsed into common usage now, because somebody came up with that
Yeah.
name, and like it's not one company selling kiwi brand gooseberry, whatever the.
Also, kiwi is like used to describe New Zealanders, and they use that honestly quite a lot in New Zealand for a lot of things. So I'm sure it's
It was
useful.
named after the New Zealanders because an American went there, saw Chinese gooseberries, he's like, how can I bring this to America?
So he might have been able to actually trademark it early on, but I mean now you wouldn't be able to enforce that against everyone, because everyone who sees it, it's like it's kiwi. I don't even. I consider myself a smart guy. I did not know that it was a Chinese gooseberry. So, learn something every day. So trademarks, like patents, can be licensed. So one fact pattern, and I was actually just talking to a new client about this, was like, well, there are different levels of trademarks. You can register your trademark with the federal government through the trademark office. You go through an examination process that's not unlike the patent process. There, the test is really just, is your term that it's sort of putting it on that scale of too descriptive to fanciful and deciding that you're close enough over here, and also that it's not suggestively similar to some term that somebody else has used for similar goods and services. So you go through the registration process. That's one way to get a trademark. Another way is to just start using the name in commerce without doing any registration.
And can I throw the TM symbol up there if I haven't filed?
If you haven't registered, I think TM, I believe, applies even if it's a common law trademark. R means it's registered.
R means it's registered.
So
R with the circle.
you can
around it.
effectively get your own trademark rights just by using some label in commerce. However, having it registered with the trademark office allows you to get statutory damages, which means if somebody starts selling stuff knocked off with your same name, you can go after them and say, you owe me X amount for every instance of this, without having to sit down and prove that they caused you some financial loss. So there's a benefit to, plus when you've had it registered with the federal government, it's easily searchable. Usually you won't have some mistake of somebody registering at the same time. Do we have to finish?
We do.
We're having so much fun.
I know, but unfortunately,
I
they
know,
have
but-
to go up the hill to LBL for a cyclotron tour.
Oh, you're going up to
So that's it.
cyclotron.
You don't
All
want to
right.
talk about copyrights instead of seeing a cyclotron? I don't understand.
Let's
Anyway.
do. I think the piece on government ownership and tech transfer is actually really important because you're going up to a DOE lab. So we'll do it in 3 minutes.
3 minutes, perfect.
Knock yourself out.
No, it's you.
No, I don't actually. This is kind of out of my area. So yeah, I think you guys did talk about export control regulations
we
earlier.
did,
So
we
that's
did, and
flow right through.
secrecy.
Secrecy orders.
Yep, exactly.
So yeah, I'll do this in less than 3 minutes because I don't know very much about it, other than to talk to your lawyer who does this stuff. We have somebody who does this for us full time, and I have to deal with it. But there is the Bayh-Dole Act of or Bayh-Dole Act of
Bayh.
1980. Sorry.
Evan 5 in
Basically, this kind of goes to the same. If you get government funding for things that result in inventions, when those patent applications are filed, the government's going to take a royalty-free license to the technology. So if you're a company, the same fact pattern where you get that disclosure form when you start at a new company and it says, what do you have that you think is an invention that doesn't belong to us? There's the same mechanism there, except a little more formal. Before you actually start taking grant funding from the government, if you want the IP to be yours free and clear, you better make sure you have patent applications filed on it before the grant funding starts rolling in. Because once the grant funding comes in, you can't really say, well, those dollars went for this and these dollars went for that. It's all commingled, and they're going to assume that it's theirs, and they will win. And then basically the government has a number of acts that Congress has passed over the years that are designed to encourage various government labs and other government agencies to support small businesses. These do come usually with the catch that technology you get from them is going to have some strings attached, but there is an awful lot. There's still a lot of government funding in a lot of areas. I'm sure in the energy space there's quite a bit. It's worth checking into and talking to your tech transfer office, especially if you're at a university and you've got inventions that are moving along. It's probably good to go meet those folks now, because when you decide to do your spin out and come back to talk to them, maybe they're not going to catch any better deal, but at least they'll make it a little bit less painful. So,
All right.
there we go.
Let's do any closing words for these folks.
I've been talking for an hour plus. I'm tired.
He's
so
tired.
I got nothing else to say.
All right, I will say one closing item, and that is if any of you are looking to figure out where there might be intellectual property located in DOE labs and in a handful of universities on a particular portion of what you're working on. There's a website where you can go to that will cruise DOE labs for PTO, both issued patents as well as applications where there's been Department of Energy in the government field of use section, and the URL is techportal.eere for energy efficiency and renewable energy, .energy.gov. So that's techportal.eere.energy.gov. It's not just for renewables and efficiency, it's for all non-classified DOE patent filings. And with that, thank you all so much for your time, and thank you, Mike. This has
Thanks
been
for
great.
listening.